Welcome to In the Courts. Tonight, a special episode. State courts, well, they've been thrust into the national spotlight recently, and tonight we're going to devote an entire show to what that means for you. Let's get started. After the Supreme Court's decision in Dobbs v. Jackson Women's Health overturning Roe v. Wade, you've probably heard this a lot about what the decision means. Take a listen. Last month's Supreme Court decision to overturn Roe v. Wade leaves abortion law up to the states.
Abortion is no longer the law of the land. It's up to the states.
Simply leaves the issue up to the states.
Abortion becomes a states' rights issue.
The consequence is it returns to where it was the first 185 years of our nation's history, which is elected legislatures make that decision.
The states can overturn a constitutional right for 50 years, a constitutional right.
But what does back to the states mean exactly? That state lawmakers can pass laws banning abortion? Yes, but it also means that state Supreme Courts can decide whether a state constitution protects the right to choose, and that local prosecutors can decide whether and how to enforce laws criminalizing abortion. And guess what? In many states, all of those people I just mentioned are elected lawmakers, judges, and prosecutors, making state and local elections even more important. Typically, only 15 to 27% of voters participate in local elections, according to the National Civic League. Tonight, we're showing you how local elections really matter in the courts. Now, the vast majority of criminal cases are handled in state courts, and in a criminal courtroom, there are three players, essentially, all right? There's the judge, the prosecutor, and the defender. Now, 2 out of 3 of those, they're often elected to their positions, the judge and the prosecutor. Also, a few states elect public defenders appointed to represent the criminal defendants who can't afford a lawyer. But 2 out of the 3 centers of power in a criminal courtroom, in one form or another, have to ask the people for their vote. Now, elected judges and prosecutors, they can wield a tremendous amount of power beyond a single case. District attorneys have a lot of discretion in what types of cases they choose to charge or how much they charge, and not much can be done to object to those decisions. So it's no wonder the political parties have turned the heat on local DA elections.
District attorney, you may not think that's important. It is enormously important because district attorneys are on the front line in the fight for police department reform and criminal justice reform.
There is a concerted effort by the left wing in the United States to elect progressive prosecutors and district attorneys that will turn a blind eye to criminal behavior. But there's good news in this, right? What are we seeing? The American people are pushing back.
Later in the show, we'll sit down with an expert to talk about the many ways that local district attorney elections impact you and your community. Meanwhile, state judges, they're elected too. Federal judges and the justices of the Supreme Court, they're appointed to life terms, in part to prevent them from being subject to the political whims of the people. They're supposed to be insulated from politics, even though that's not always the case. But that's not the situation for many state court judges. In fact, in some states, judges run with a political party. This year, about 2/3 of the states have some sort of state Supreme Court election on the ballot. And these races are often under the radar, but they have massive consequences. State Supreme Courts, they're the final decision maker on major issues like gerrymandering and voting maps. Now the right to privacy or the right to choose to have an abortion, that's up to state courts. And state Supreme Courts are the next battleground for individual rights. Coming up tonight, we talk with a reporter steeped in state court elections and on what to watch for the midterms this November. And speaking of gerrymandering, the power of the states, the Supreme Court, they're going to hear a case next term that combines all of these issues and could be the most important decision out of the court in decades. Yes, in decades. I say that after the term that we just had. But this case is about how federal elections are run in individual states.
The notion would create election chaos, disenfranchising voters and overwhelming election officials. The claim would undo hundreds of election laws in state constitutions enacted by ballot initiative and implemented through administrative rules. Policies enacted through direct democracy, like mail voting, same-day registration, and even voter ID, could be wiped off the books for federal elections.
The case is called Moore v. Harper, and it involves a dispute in North Carolina over the state's efforts to draw new congressional maps after the 2020 census. Now, the issue at the heart of the case is something called the independent state legislature theory. With that kind of legal jargon, you know we got to ask, WTF is the independent state legislature theory? Even the term makes you want to fall asleep, I know, but I promise this one is important. It's about who gets the final say in how elections are run by a state. The state legislature, made up of representatives elected by the people, or the state Supreme Court, who is supposed to be the neutral decision maker for legal questions, including legal questions about elections. Now, the independent state legislature theory comes from the Elections Clause of the Constitution. It says state legislatures have the power to set the time, place, and manner of elections for senators and representatives. Now, this issue may sound a little familiar to you. It actually came up in Bush v. Gore back in 2000. There, the Supreme Court stopped the recount in Florida for the presidential election. And then Chief Justice William Rehnquist said that the Florida state court's recount conflicted with deadlines that were set by the state legislature for the election. So, fast forward now. The GOP-controlled legislature in North Carolina redrew the state's congressional maps after the 2020 census. And Democrats, they challenged the map in state court, saying it would likely allow the GOP to pick up 2 extra seats, taking as many as 10 of the 14 available congressional seats in the state. They said that was partisan gerrymandering and violated the state's constitution. Now, the North Carolina Supreme Court essentially agreed with the Democrats and ordered the trial court to adopt a new map, which they did. So now the Supreme Court is going to decide if the state Supreme Courts have any oversight over federal elections and how they're run in individual states. And this decision could affect voting maps, voter ID laws, what technology is used to vote or count ballots, and same-day voting, all kinds of things.
You really believe that the U.S. Supreme Court will decide that state courts do not have the authority to interpret and enforce the state constitution? You really believe the U.S. Supreme Court will go that far?
Well, I'm not going to make any predictions here, but I can tell you that Justices Alito and Justice Thomas, at the least, have signaled that they are very disturbed by, this is in the context of Pennsylvania, state court constitutional rulings about state election law. So there's no question that that's a serious issue before the court. And there are some indications that at least some justices are prepared to accept such a view.
Now, either way the court comes down on this one, the case reinforces the importance of state elections. And by the way, another major state elected player whose job has an impact in the courts, that would be your county sheriff. That one will have to wait until the next special episode because we've already got a jam-packed show for you tonight. Coming up, there's some pretty big state court elections on the docket in your area. We'll tell you where and what it can mean for you after the break.